So I'm turning on the microphone. I guess we are live streaming. This is the work session for House Bill 1368 in legislative administration. Um, we have a limited audience and a limited committee, um, but we certainly can have a discussion on um, where the where the responsibility lies with the legislative committee dealing with House Bill 1368. From the lowest possible bar, our charge is to decide whether the legislation is worthy of going forward in the next term, or whether we believe it's reached its usefulness and will terminate here. Doesn't mean that future legislation won't, however, be, or the same legislation be resubmitted in September. But what I would like to do, this is not a hearing. I want to make that clear. This is a work session, so, and it's meant for the committee members to discuss amongst ourselves and pull it apart and decide ultimately whether the legislation should go forward or be recommended to terminate. Um, I'm going to run this very informally and let everyone talk the way they want to from the committee. If there are questions that you have, committee members, that you would like to address to the member of the ethics committee that is also in the room, um, I'm going to allow that. I wouldn't have had there been additional committee members, but additional people in the room, but I'm going to try to do this as informally as possible, and if anybody um, wants to go from there, we certainly can. Um, my goal, just to set the table a little bit, my goal is to, with legislation on conflict of interest and recusal, um, is always to create something so simple that any member um, who listens to a piece of legislation can, in their own mind, without consulting their family attorney or anyone else around them, make the determination um, fairly rapidly whether this is rises to the level of a conflict of interest and whether they should recuse themselves from the debate and or from the vote. Um, I don't I don't want this to get to the point where it rises to a complaint and therefore it's something that the ethics committee has to deal with. Um, in the past, we've seen cases, I believe, where uh, the ethics committee has acted on complaints and the confusion of the existing rules and regulations were such that a shrug of the shoulders and a slap on the wrist was put forth just because we couldn't understand the rules or we thought we were on the right side of the rules and therefore um, it was not acted upon. I think we should be able to create, I'm a black and white guy anyway, and I would rather err on the side of recusal than not, but that may be me. So with that, with that background of what I'm looking for as just a member of this work session, maybe everyone else would want to chime in of what they're looking for, and what problems um, or pieces of the legislation they particularly enjoy or want to see removed. I think all of that would be helpful. So with that, I'm pretty much going to just step down as chair and be a work session participant. Anyone want to go?
I have to turn this on.
I think you do, so you can stream.
So the questions that I have whenever I take a look at bills, especially ethics bills, is I always go back to the underlying definitions of what I'm doing. Because in order to rewrite something, I need to understand what the terms mean or how they're defined to determine whether or not they are correctly put in any proposed legislation, like in this one. And when I first read the bill, I had a question as to how household member was defined, because it's referenced throughout this amendment. We talk about conflict of interest and they talk about financial and non-financial, but then almost every other paragraph that's amended here, 1A, 1B, and 5, talks about the legislator or legislator's household member. So I went back to the definition of a household member. And the definition of a household member was a little bit confusing to me and probably needed to be looked at a little closer. In today's day and age, a lot of folks that contribute to daily expenses of a household doesn't necessarily have to be living in that household. So you can have a divorced couple or a couple that is separated, and they're not necessarily domiciled in the same household anymore, but yet they contribute to the daily living. So household member, to me, I would remove living in the same domicile as the same legislator or legislative employee and take that first part of the test out of it. And I would have, and as I put forward a draft amendment, 2106H to this, that a household member shall mean any person who shares a common economic interest in the expense of daily living of a legislator or legislative employee, including but not limited to spouse, child, or parent. I think that's more in tune with what we have, because you're limited currently that you have to live in that household, even though you're contributing to the daily expenses. And so to me, for purposes of conflict of interest, it needed to be expanded a bit. So I dropped the domicile first part of the test. That was the first thing, because to be mentioned throughout this entire bill, I thought was an important thing to go back and look at. And so it includes people that are not necessarily living in the same household. And it can be a problem, because when you say household member, a lot of people may think that you have to be in the household, and that's why the domicile was there. So to remove it, I think is a big step in including people, to have them think about, well, geez, could I be considered a household member? So then the next thing is, and I didn't address this, do you want to have household member, or does it need to be another word to make people, look at it? Should it be family member? Should it be whatever it is? I don't know. But to just kind of go with what was in here, if I changed the household member, I felt much better about including more people to look at whether or not they had a conflict or not. So that's what I did. That was one of my things. And whether or not we pass this legislation, recommend this legislation to be brought forward again, I think that maybe a little bit more in scope needs to be looked at, just other than the financial and the non-financial interest. But I wasn't a member of that committee, and I don't think we really went into this when we had the hearing. At the time, I have to be honest, I didn't go back to look at the definitions of everything until I read it again. We knew it probably was going to be retained to look at it, interim study, and that's when I really kind of went into this thing. So that's all I have to say.
While you're on the household member definition, did you do any consideration or any thought about the common economic interest piece, that phrase in there? Because I'm not sure that average legislator sitting in his seat in Reps Hall would say common economic interest. What the heck is that?
Which number
Because
is that in, Greg?
that's right in definition 14B1 definitions.
Oh, you're talking about looking at the definitions of the statute.
The current statute.
Okay, not the
talks
bill
it-
itself, okay.
That's where that same domicile comes from, that
Yeah.
same line. It says a common economic interest. I can see people saying, I need a definition of that, because down below, it talks about a financial interest exists, but it doesn't talk and a non-financial personal interest exists.
Well, I think the way I read that was when they share an economic interest in the sentence, in the expenses of daily living, that's how I had defined economic interest in the expenses of daily living. So I didn't look to change that because I kind of equated it to be the expenses of daily living.
So is economic the same as financial?
I think might be.
But
Good question. I don't know.
but in terms of the consistency here, so it would seem to me that household member
Yeah.
definition,
Change economic interest to financial interest.
well, but we also talk about non-financial interest.
Mm-hmm.
So do we not use that household member definition when it comes to a non-economic personal interest?
I think it could.
I know, but this is the part that you can see
Yeah.
where someone has to make that decision. If there's not common language used throughout the definitions.
So then, are you thinking, I did not think it was, and you can get in this rabbit hole and not get out of the rabbit
Well,
hole. And
yeah.
and we're probably pretty deep into the rabbit hole right about now. So I'm thinking, household interest shall mean any person who shares an interest. You got me. Or maybe who shares the expenses of daily living.
Or
Take
even
out the
just-
whole thing. I mean, I don't know.
Or even just uses the same language, and so it would say the House of Representative Senator who shares a financial interest or a non-financial personal interest.
Correct.
So uses the same language
Yep.
rather than creating this economic interest.
Yep, I agree. Yep. Another amendment to the amendment.
Yes?
Yeah.
Maybe this is a good time to ask whether Mr. Lambert could chime in whether that was considered and not considered. If you want to jump up to we won't call it the witness table, we'll just call it come closer to the work session.
I'm not saying what I was thinking. Go
Yeah.
ahead.
Just come. It's not even the hot seat. It's just
It is the
trying to
hot seat.
This
have a conversation. You
issue
see-
of conflict of interest has been the most complicated part of this from the beginning. It's gone through several changes, both in terms of definitions and scope, and also the various forms. So yes, that's been talked about. For a long time, the requirement was spouse, period. So this was expanded already. And financial interest also uses the term household member in its definition. So, I mean, we have three entities here, the guidelines and two statutes, which all have pretty much overlapping definitions in some cases. So-
Not just overlapping, sometimes they're completely different words, maybe describing the same thing, but
So on
But not
page 26
same
of the
language.
booklet in 14B, special interest is defined, and then that's broken down to what you were just saying, Mr. Chairman, a financial interest and a non-financial personal interest. 26.
it's the same 14B1 definitions that we've been talking about. Okay, I'm just pulling it off the statute, that's all.
I got the two notes, but he said it's also.
It seems that using that special interest definition, when the legislation was done, the phrase distinct from and greater than the interests of the public at large were deleted or omitted. But I don't want to jump into that subject until we get off of this one of whether a common economic interest is the same as a financial interest. And if that's the case, why not use the financial interest language? And does the household member not also have a non-financial personal interest?
They do.
But it's not mentioned in the household member definition.
Well, that's true.
And this is where the confusion lies for that person that's not an attorney, that's trying to figure out for themselves, do I have a conflict of interest with this piece of legislation? When you start getting the definitions, and this is the key, the definitions, well, devil is in the details, right? The definitions, that would be the first place that I would go as a legislator to determine whether I have a conflict. I would read that household member and say, a common economic interest. Oh, great. It's a non-economic interest that I'm worried about, so therefore I'm fine. Well, until you read down below and it says non-financial exists, and now I'm confused and I don't know whether to recuse myself or not.
Well, generally there would be no, you would not have to recuse yourself. The question is disclosure. And that's the other area where, because.
See?
So the issue becomes so what direction you have to go. You can't get to that point unless you have the definitions defined precisely.
Right.
And so what Greg is absolutely correct. Common economic interest should be financial or non-financial interest. There's no question. That's one thing that has to happen. But we really can't just say that they live in the same domicile. That can't be if you're going to import non-financial interest. You see?
I do.
So that's where my issue began.
And like I said, this
And I'm
was,
not offering to be honest.
And I feel like we're nitpicking, and I'm not
No.
trying to be that. I'm trying to get to the point where we're using the same language in every area for that simple purpose of letting the legislator decide for themselves, not having to go to you and ask if they have a problem. That's my bottom line, is how do they decide for themselves?
well, I know that when members come to me about their financial disclosure forms,
Mhm.
a lot of them they were confused about it, but they're happy that there's some sort of line drawn where in the domicile is stated, because they'll say things such as, well, I don't know what my kids' interests are, or, I have no control over what they do, and would I have to file an amended form every time they do something that changes their economic interests. So that's the kind of issue in a practical sense
Yep.
that can
I can see that, but also in the case that that Representative Roulard brought up, what if you are still controlling the economic interests of your family, but from another location? You are a divorced parent or something like that. Certainly that would be an issue if.
Yes.
So even within just that one little phrase, we've got two diametrically opposed situations. One you would, one you wouldn't. So, but it doesn't help when you're using different phraseology to describe the same,
different units of measure.
yeah, different units of measure. I like that. So at any rate, I don't know how we resolve.
I think also, the other thing, as I'm sitting here rereading this again for probably the 100th time, on the bill itself, under Roman numeral 5, special, and I get it means financial or non-financial. I get it, I guess, I bet it does. So, and that's, they changed financial and non-financial to eliminate the last sentence here, substantially greater than the benefit or detriment would be through a business or client. So why is that in special interest versus stand to gain or lose anything of material value? So why would we have a financial interest and a non-financial interest be a different burden or a different test than we have a special interest? So you're pulling back the old language from financial and non-financial and sticking it back in special interest, which, by the way, reduces the mess. And it also has household members still in there, which needs to be redefined.
For many years, conflict of interest was defined as financial interest, period.
And it is in many states still.
Still.
They ignore the non-financial.
It was the recommendations of the study commission that changed that.
In 2014.
14, and it was passed in 15 by
Okay.
legislature.
Was that done for a specific instance, or was it just looking at other
They were looking at everything.
states?
And the thought was that right along, the thought has been that most legislators want to conform with these provisions, but in a lot of cases they don't understand them because they're complicated. So the commission looked long and hard at conflict of interest, and there was a discussion about requiring recusal. That was not only about 2 members agreed with that. Others were very strongly opposed to requiring recusal. So instead, they then focused on strengthening conflict of interest to add more to it, such as the non-financial personal interest. And that's when they moved financial interest into this new term, special interest. That was a creation of the study, a recommendation of the study commission. So that now this bill would reverse that in a sense, because you're taking out financial interest and non-financial personal interest from the definition of special interest and putting it under conflict of interest, where it used to be. Because I think that Representative Gordon wanted to have a term that would define when you needed to recuse.
But nowhere did we see in here just disclosure is, there's no table for saying in these circumstances you disclose and in these circumstances you recuse. And those are the 2 options, right? I mean, there's not a third.
No.
that isn't also mentioned.
No.
Okay.
So they bulked up the disclosure by adding non-financial, but also requiring verbal disclosure. So that, and that applies to the broader definition of when you have a conflict of interest. For example, the retirement system. If a legislator or household member is in the retirement system and you disclose that on your financial disclosure form, and a bill comes along that affects all members of the retirement system equally, you don't have to file another form. You don't have to file the declaration of intent form, but you do have to make a verbal disclosure at certain points when you're engaging in advocacy. That was the idea that then, because the thought was, well, these forms just get, filed away somewhere and no one knows if you're, or another example, if you're a landlord and you're testifying on a bill that helps the landlord side of the landlord-tenant issue. Maybe you file some form somewhere, but it's not really readily known when you're testifying. So from the result of this change, you need to say, yes, I'm a landlord. And then you can make your argument.
Go.
So I have a question. The way the bill reads now, under conflict of interest, they have A and B, financial and non-financial. The way the bill reads now, that was submitted, a financial interest exists where a legislator could stand to gain or lose anything of material value as a result of the official capacity. Would that require that legislator who has a financial interest, that's a member of a union or the state employee gets a pension, what would they be required to do? Would they have to recuse, or would they have to just disclose?
Disclose.
Then why bother?
And how would the person that's reading that definition know that they would be disclosing once you're entering?
So if they have, exactly, and if they have something that they are going to gain financially, why shouldn't they recuse?
Well, right now, they're not required to.
Well, I know, but that's what we're here for.
Yeah.
That's what we're here for.
But ideally, that's a policy decision that for,
I
So,
didn't
you
read
know-
disclose anywhere in any of these. Did you ever see anywhere that
they have
disclosure was
disclosed.
a different?
No, but, you
Yeah.
know,
it's in the guidelines.
And where in the guidelines, what page?
Begins on page 7.
17?
7.
Seven. We have a problem.
Disclosure.
And particularly on 12, which is the conflict of interest procedure.
But, okay, so it says you have financial disclosure form, okay, under 5, is that what you're talking about?
That's
And
part
what
of
was
it.
the next thing you just said?
On page 12, part 6 of the guidelines.
Did you bring extras of those? Perfect. Hmm? Yeah, mine's in the car too. Thanks very much, Rich. No pun intended.
Under
Did you
conflict of
know about
interest, no
disclosure as a
legislature has
freshman?
Conflict of interest on page 12, part 6. Participate in any activity
No.
associated without complying with the procedure. Okay.
And I guess I still come back true to your question, Claire. What good does that do us?
What good does it do us to have
when-
that in there when you have to just disclose as a conflict?
Well,
Was that
because it's
discussed
been-
in that?
Because recusal was discussed. I mean, there were, Gary Richardson has been an attorney for many years, and
Mhm.
any attorney knows that, you don't disclose anything, you recuse from a case if you have some sort of conflict of interest. But that's always been, I mean, you could go back to the beginning when former Senator and Congressman Charlie Bass established this committee. They talked about recusal then a little bit, but they felt fortunate to get past what got passed. It took many years to have an ethics committee because the thought was that this is a citizens legislature where people have, not paid, they have jobs and interests of their own. And many times constituents, the argument is, constituents are voting for people because of their expertise in a certain area, perhaps.
Right.
In agricultural areas of the state, it's important to have people represent the interests of farmers and logging interests or whatever. And so that's why it was based on disclosure most of the time. And when I say most of the time, because it's this other provision, part of the guidelines, the prohibited activities. And that is something you could look at too, which is what the two aspects of this came together, bumped together in the complaint, 2 of our complaints that you have. One against former Senator Bragdon and one against late Representative Lay. Because we have always been careful in any sort of orientation or continuing education to say most of our guidelines require disclosure. But that's not always a solution, the remedy to you having a financial interest. So there are some circumstances which are laid out in the prohibited activity section where you can't participate, and disclosure would not solve that.
Can you give me an example of that?
And that's why I think Representative Hill was referring to that. The committee didn't go forward with any sort of serious sanctions in those cases because Representative Lay argued that he made disclosures, that he was president of the union, if that's what he was, president. And he thought that's all he had to do. But if you look into the prohibited activity section, which is, I keep having to refer you to these things, but
In 4?
yes. Page 4.
Yeah.
In fact, that first paragraph, I, was added by the study commission to clarify that there are some circumstances where disclosure does not, you can read it yourself, excuse or absolve from compliance with the prohibited activities. So legislators shall not solicit, accept, or agree to accept anything of value from other persons, knowing or believing they may be wanting to influence you or the legislation, in all those circumstances. Or D, if you were employed by someone who was interested in legislation, you can't introduce legislation or testify if you were receiving something of value, such as a salary from that entity. So it's getting more complicated, I know.
Yeah.
So it not only becomes complicated, it's circular. There is no end point at any of this.
There's
It's
no bright
one
lines.
Big circle. And the problem that I have with, if you have a financial interest, either you or somebody in your household would like to have it no longer living there, has a financial interest, they can disclose that when they fill out the form before they're sworn in or after they're sworn in, I forget when it is. But I'm not sure that we should have those folks voting on legislation that would directly benefit their purse. And that's the problem. And now, with
one of
regard to farmers coming to testify that we need this pesticide or we don't need this pesticide and this would help them, that's a little bit different than them coming to testify on legislation to prohibit a pesticide or not to prohibit a pesticide. That's not a direct financial interest, even though they're a farmer and there's legislation coming forward. I'm not sure that that's in the prohibited activities or not. If they are introducing something with regard to farming, I would want to, as a legislative member of a committee that's listening to that, I would want to know what they know about this. So, I mean, I certainly don't want to be critical, but I guess I am. So
It's
I
hard
guess
not to be.
I don't know with any of this. I don't like being in the circle.
Well, there's no bright line. That's been the problem.
Can we make
No.
a bright line?
The commission's tried to do that, but it didn't. And what we're talking about is strengthening the guidelines considerably. And I just think it's not my job to talk about the politics of it, but I don't think there's ever been support. Or
Does this
people
do
thought there
that?
was support.
Does this brighten the line that
It
the
would.
legislation? In what areas? In what specifically? What it? I would think in eliminating that distinction from greater than the interests of the public at large, that may be one example of clearing up the haze.
But it's in paragraph 5, special interest. It talks about that. Substantially greater than the benefit or detriment would accrue to businesses or clients. I mean, isn't that what you just said was released, was taken out? That was taken out under the financial and non-financial interest.
Right.
But it's not taken out under special interest.
Circular argument again.
My circle. I'm
No,
sorry.
it's crossed out under special interest. Is that what you said?
Yeah.
But it is in where?
Right here, which
It-
is
it is
Oh.
substantially greater than the benefit.
It's in special, it's in the bottom, substantially greater than the benefit or detriment that would accrue. Isn't that what we're talking about?
It's not. This is different.
Substantially.
It is a little bit different,
Oh.
but this is very confusing.
You think?
It's not about, it doesn't say, you know, this is, you're out.
Are these in any way, were these developed in-house specifically, or was there a review of what other states are doing? Did we try to recreate the wheel, or did we use what works other places or not?
For this bill or over the years?
Well, both. How's that? I guess I was thinking when I asked the question in the 2014 study committee, did we go out and look at?
They did. I was not the staff person. I was there, but Pam Smarling, whom you remember,
Yep.
did a great job doing that, getting all other states' provisions.
That's what you were talking about, Jen,
Right.
that your report came from? No.
Yes, the document, like the 50-state review.
Yes.
Document, Pam created that. I think she created it for that commission.
Okay.
And I updated that for the Ethics Committee and for Chairman Gordon's bill
Okay.
to see if anything had changed from NCSL.
I thought you had a comment. No? Okay.
Appreciate the update.
I still think we are almost, I think I can almost go to the point of saying we're making it worse by adding additional or adding additional definitions, but using new language instead of using the old language. And it doesn't seem that we are giving, expanding this ethics booklet doesn't make it clearer for that average legislator, as far as I can see. We had a situation the other day. I was talking with an existing legislator who said he was a substitute in Ways and Means, and when he got there, he found that one of the bills that they were execing, he had a conflict with. But he said, not having my ethics book with me, and he wouldn't have had time had he had it to go through and know whether he should have disclosed and or recused. And then this is where maybe a rules change needs to be made so that he could say, I'm sorry, I have to recuse, but he was inside that 24-hour period and he wouldn't be able to remove himself from that executive session and have a new person come in that didn't have an issue with it. So this has tentacles, I guess is my point. We need, from one set of facts, we need to keep changing something else down the road as it gets influenced.
There's many moving parts.
Yeah, yes.
Well, we tried to help a little, I hope we did, with Interpretive Ruling 2016-5, which is on page 64 of the booklet and was at the time published in the calendars and also is on the website. Because including in that, at the end, there are some hypotheticals.
Would it ever be possible, Mr. Lambert, to have something as simple as a decision tree, or, are we talking about your spouse? Yes. Okay. Are we talking about a job that your spouse has that, that does this? Yes. So that the simpleton legislator can just go down through and say, okay, here I have to disclose. Was that ever discussed in?
No,
Okay.
but that's a good idea.
Then you could laminate it and hand it to the legislators and rather than say, well, on page 65, there's something that's close to what I'm talking about that this guy did do that.
Well, if you look at page 68, there are sections examples, actually 67 and 68, and they do say declaration of intent required, yes, verbal disclosure required, yes. So they give certain examples, kind of like what Greg is
Yep,
talking about.
yep.
Probably should put that on, sorry. Kind of like what Greg's talking about, that, you know, there are some, but it doesn't, when do you have recusal?
Well, that's what Chairman Gordon, I remember saying to you, if you read through this, there's no place that says you must recuse. And it's been up to the committee through some interpretations and some complaints to establish some criteria for that.
Right.
And once again, it would go back to the prohibited activity section, because you can't have a lobbyist give you money or something to put in legislation. I mean, if you disclose that, you know, still it's a crime beyond the ethics materials, even under criminal law, I would assume. But that's why the committee, that's what led to this, because the committee felt it should be clearer and also statutory, not only based on the committee's interpretation as they applied the statute and guidelines to a case, as they did twice.
So Ned tried to put in this legislation, recusal. I don't see that word anywhere in here. Oh, yes, I do.
Yeah.
14C:4A, recusal for conflicts of interest. Shall recuse himself. And again, then we get into, okay, an official legislative activity
Special interest
defined in
again.
B1. Where is that? I know, but where's the official? We don't define official.
Yeah, we do. I think
legislative
it's in the
activity.
guidelines.
Profit or not, yeah,
Where?
Page 3.
agree.
Of the book. Official business means,
Official activity.
and official activities are,
So I like that recusal portion of it, but I think that the conflict of interest is kind of wishy-washy. And we need to kind of shore up some of the definitions to comply with what financial and non-financial and special interests really mean, and whether or not they require recusal.
I think I actually like 14C:4A as a piece.
Yes,
It's simple.
yeah,
It gives you 4 examples
yes,
and when you need to recuse.
whether or not nonprofit or for profit.
Right.
Yep, I like it. That I like. But the conflict of interest piece of it is a little confusing. And I got that. And I think the household member, and they also have the word, in the household member as common economic interest. So that would almost have to be changed.
Well,
Under the definition
they
of
also added
household.
not only economic interest, now they've got the word is receiving remuneration. So we've got another word for the same thing.
Under the first part of it,
Under
receiving
under Roman 2,
Yeah,
Roman 2 is receiving from an employer,
remuneration, yeah. right,
which
I get
has
it.
a special interest in the official legislative activity.
Is that defined anywhere? I don't see it.
I don't know.
I'm sorry, I didn't hear that, Representative.
Remuneration, if you have it,
No.
if you have,
No.
which is Roman numeral 2, under the conflict of interest refusal.
So it would seem like we've got,
You got to turn on your microphone.
so it would seem like we agree that there's some good things in this bill to move forward with some changes. Is that? Or we kind of,
No, I think
will we
So,
kind of have-
so yes, so yes, there are pieces that this is my,
Sure.
there are pieces in here that make sense,
Yes.
but when you are
When they're-
adding language to 65 pages, are you really moving the ball forward?
to make it
And
more
are you-
applicable simply to legislators.
It still comes
in the
back to
field.
me that there's two, and I'm not accusing Ned Gordon of doing this, but are you putting all of this in language in order to use it when a complaint is made after the fact?
In a
And
reactionary
be
manner.
able to use it to say, see, this is where you went wrong? Or I would prefer
To prevent such activity, yes, the old adage.
before the fact.
An ounce of
And
prevention's
be
worth
able
a
to
pound of
have
cure.
someone, without having this on their person 24/7, have someone be able to say, I think I know where the clear line lies for my family members, what things I can vote on, what I can't, and what things require just disclosing, and what thing, although I have to agree, I think, with Claire that disclosing is for me, to the general public, disclosing means nothing.
Yeah, I agree.
You're either, and for the same reason, I've never understood if your benefit is any greater than anyone else in your group. If it's a benefit to you, then it's a problem, as far as I'm concerned.
Right.
And I would rather err on the side of recusal than the side of disclosure. And I don't think the public, for the purpose that I don't think the public looks at disclosure as being
Yeah,
your
that does nothing for them.
absolution. That, and I'll grant you that just may be my personal view.
No, that's my view. I mean, I think disclosure without having to recuse, you may still want to fill out the form, the disclosure form, when you're filling out the forms when you are coming into the house. But that doesn't give you a pass to vote on things if you have a special interest, financial or otherwise,
Correct.
to vote on legislation. So that almost requires recusal. So, maybe I'm thinking too much about it, but I just have more questions now that I've come in here today than I thought I had. So
That happens a lot.
with me, it does, yeah.
Actually, probably our freshman legislator, or almost not freshman legislator, we've dealt with this stuff for years. It may be more important for us to know your view. Is this overwhelming for being handed a booklet and told, these are your new ethics, and this is when you do or don't? I've always erred on the side of, I don't want to be involved in something that I shouldn't be. What do you get from all of the instruction and all of the guidance that you've received as to the state of when you disclose, when you recuse? Do you have or are you just puzzled beyond
And
belief?
include this conversation here today. I don't know.
Yeah, did
that
we
you
help you
can.
at all?
Did this help? Does this make it more confusing, or how do you feel about this?
Well, I think that it brought up some issues that need to be looked into.
Yeah.
In a previous conversation, it was said that we need to bring the language down to a level where everybody gets it. And, there was even some bills that came up this past year that I asked my chairman, should I recuse? Because again, I'd rather fall on the side of
Me too.
safety and being above board than to just,
Wing it.
yeah.
Were you given, it's been a while since any of us had gone through orientation. I'm not even sure. Are you giving the orientation conversation or are
I've
you?
usually been part of it. I didn't last time, but Chairman Gordon did
Oh,
for the House, and on the Senate side, he did it with Rick Lehman.
oh, okay. Um, well, both being attorneys, you know, you're getting the, I don't know if it's even the client attorney conversation, you know, don't answer that, you know, I'm wondering whether the instruction that you're getting that comes from this book is suitable for you to be able to make decisions
Well, if we,
without going to me and asking
if we
you.
went by just the book alone, it's already been said that there's no fine line to recuse. So if they're teaching from the book, recusal wouldn't have even come up, right, in the teaching?
Correct.
That's how I understand it.
We find that surprising.
I do.
I think most people of the general public would find that surprising as well. All you have to do is announce and then it's okay to go vote. And that, I think, is the problem that we're trying to eliminate.
So does that mean, so where do we go from here? We can do this all day long. Do we look over the summer for things that, and continue to talk to and read the 50 other states and find things that we think should be in here? Or do we simply jump over the low bar and say, the legislation should go forward? Or do we, what's the will of the work session?
I don't know that we should say the legislation should go forward. For study should be done on ethics, definitions, and recusal.
Another study similar to the
Well-
2014 or?
Well, we have to have somebody. I mean, what is it that the folks put together here? How did that come about? Was it because just the ethics committee? Do you need a study or do you need just the ethics committee revisiting the issues that we've brought up today with definitions and adding? We know we have recusal in here, which is good.
Is this bill the product of the ethics committee or is it just Ned's? I don't
well,
know.
He certainly kept them in the loop and talked about it at the committee meetings.
Okay.
I don't recall that there was never a vote endorsing it that I can recall,
Okay,
but they did seem to be in support of it. I know that Representative Wall is on it. And I don't know why Senator Carson or Senator Rosenwald aren't, but they were asked. Maybe things happened too quickly or something, but they seem to be in support of it.
it's kind of an odd committee anyway. It's not, it's not a statutory committee.
It's sort of,
I think it
Is
is.
it?
yeah,
Yeah.
it is. It's a
So
stat-
it's not a standing committee, it's a
No.
statutory
Right.
committee. And it is, but the membership seems to remain pretty constant. There's actually, it's almost a commission too, right? There's
It's 3
non-legislative.
public members.
It's, I think it's unique. But I don't know, I don't think that really changes how we are looking at the bill before us, right?
I think the idea of recusal is good, but even in the recusal section of the bill, there's definitions that have to come in be defined. Remuneration, even with the household definition. The household definition in statute currently needs to remove the common economic interest because we don't know what that is and it's not defined anywhere. We can imagine what it is. And we also have to really shore up whether or not we have a special interest or if we have a non-financial or financial interest. Those have to be all defined. And only once those are all defined can you go back and decide whether or not what you're going to do with this ethics book as to whether or not you're going to have a recusal section in this book, which I think they need. And so that's my take on it. Whether it's done with a commission, whether it's done by the committee, the ethics committee that's currently in place, or whether it's done by Ned Gordon, Cindy Rosenwald, Sharon Carson, or Janet Wall, I don't know. But we here, sitting, the four of us, this isn't it.
But there's also in this book, this is the charge
I
of the
got
ethics committee, right?
Yes.
To create this book.
And policies, right?
And policies.
Right by the charter.
But this bill is putting it into statute.
Correct, which is part of this booklet. It's in, all the statutes are in. here.
Right. But even if we pass this as it stands, it still needs to get into this book by the ethics committee. They are the ones that take and put the statute into this booklet.
Well, clearly that's true, but if we give them language that's going to be statute language, they're not gonna be able to fix that and comply with all the other issues that we have. So even if we pass this bill, we've not done justice to editing this book.
No.
Just a thought.
Well, if you amended the two statutes, we would change them in here to reflect what's current.
So if we change the definitions and
Oh. Yeah,
in statute, it would drive
yes, we would.
the,
Correct.
Now, one place you could have less volume here is if we remove the procedural rules, which only are really come into play for a complaint. But it was always thought everything should be in this booklet, even though it does make it longer. That applies to the ethics committee.
you know, as a side note, whenever I ask someone at DOE a question and then they say it's on the website, just because it's on the website doesn't mean I can find it, and doesn't mean that, it doesn't absolve you of the responsibility of telling me what the answer to my question is. I mean, there used to be a cartoon, and the fellow said at one point, a point in every direction is the same as no point at all. It's true, putting it in the book doesn't help if it serves to intimidate someone from sitting down and reading whatever 68 pages or
Maybe we should have a second publication that would be a shorter version of.
yeah, the cliff notes, yeah.
The Reader's
College
Digest.
memory. Otherwise, we're going to get close to having the manual of ethics over here. And I still want, in my perfect world, I want a little laminated card that tells somebody, yeah, you gotta stay clear of this issue. And that's hard.
We need to create an app for that.
So as I see it, there are 1, 2, 3, 4, 5, 6 definitions that need to be looked at and revised. Household member, household has to be revised. Common economic interest, which is in the household definition,
Remuneration
right?
or
And
Or-
financial interest,
maybe not defined remuneration. It just may be
it needs to be defined.
using, well, but it may just be eliminated and use the existing
Could
language in
use,
there,
could,
you know?
yeah, so either define or eliminate it, right,
Right.
okay. So financial and non-financial, if you're gonna go with what's in this bill now, that's okay, but this bill is not gonna be going forward because there's all these other things. And special interest, remove the greater benefit language. So we've got household, which removes domicile, which economic interest is defined, or changed to financial or non-financial interest, right? Then financial, non-financial remuneration, either define it or remove it or change it, and special interest, remove the greater benefit, because I don't think special interest, putting that language in is helpful.
And currently, it would add substantially greater benefit. Is that
That,
good?
I'm speaking for me, I don't like that language.
I don't like it at all.
At all.
Too
If
general?
if it's your,
How are you gonna know?
what's
We don't want-
substantially to one is different than
And, you know,
another.
and so quite frankly, if we're gonna have that language,
Why
don't bother.
we want to make things work. We can do it. You can call me,
Well, it
but
would,
you know,
if, as soon as you are getting a benefit, it doesn't matter whether its benefit is greater or less than someone else's. You're getting a benefit. That's my upbringing.
There's always going to be an issue of drawing the line, though. For example,
Yes.
a bill that affects the property tax or
Well,
the business taxes.
Yes. Or money going back to municipalities or something like that.
Correct.
there should be
Current use
exceptions for
tax.
What,
those like that.
was it ever discussed of having, I mean, exceptions or something along those lines? Because there are bills, look at last year when we had the silly omnibus bills. It's possible that there's one little thing in there and you're now not able to vote on the entire, 32 sections of a bill.
Mm-hmm.
I don't, how is that ever handled? I mean, it's always just been handled by disclosure?
Yes, and the idea that so many people are affected by the property tax and still substantial people's affected by the BET and the BPT, or the real estate transfer tax, that unless it affects you more than others in that group, disclosure on the financial disclosure form and making the verbal disclosure at certain points is enough.
But that takes away the idea of COLAs in the state retirement system, right? I mean, that's the trade-off.
Currently, you could vote on that unless it affected you more than other members of the retirement system.
And that,
Currently, but not under
not
Ned's
under this
bill.
bill.
And how is that quantified? Is it on a percentage basis or
Right.
dollar basis?
Yeah.
Because, are you using a yardstick or a meter stick? It's the same.
Well, to a certain extent, you can make the argument, this is how silly it gets. You can make the argument that if you retire at 55, you have a greater benefit than
Sure.
the person that retires at 65. So, where is your,
And
Where's the
same thing with
thermometer
real
and
estate
where's the
taxes.
level and how do you get that information in order to make that
More
determination? So
property
you
taxes.
see,
yes,
we're in the weeds of it now where we didn't want to be.
Correct.
And, we do need exceptions. I got the BEP, the property tax, I got all that. Otherwise, no legislator would be able to vote on the budget.
It wouldn't be a quorum.
And so there we go. So, we have a problem with that. So we do need exceptions, but not when you have a financial interest in, with the household, with the financial, the non-financial, all of that stuff. And there needs to be recusal. I agree with Ned Gordon and Janet Wall on that bill. I agree there needs to be. And because I think the people of our state thinks there is.
I do.
I think they think that there's recusal. You're not voting on that. So this is a little bit concerning to them, I would imagine.
I get calls from the public all the time wondering if they should file a complaint. And so what I do is I lead them to the provisions on their website. And when because they have a much different concept of conflict of interest than
Sure.
is reality.
Yeah.
And so they're disappointed when they hear how limited the definition is. And so that's been going on for 30 years.
Well,
Right.
you
Well, perception is reality, right?
Yeah.
The reason that, or the explanation that you're hearing from these people saying that they're disappointed, that's what leads them to lump legislators, whether the state or federal, in that
Right.
they're all in it, they're all crooked, they're all, and that's what I would like to take a
Well,
harder line.
I
so
think,
that-
yeah. And I
so
think the ethics booklet was a start, but I think that, the four of us sitting here chatting is like, what's happening?
Yeah.
Yeah.
So, again, I'll ask the question, where do we go from here? What,
Sounds like you're looking for a
Can
motion.
what are our options again?
Recommend or not recommend?
Recommend future legislation. Yeah,
that-
we do.
that this is,
With a couple of qualifiers.
that this is, that the committee recommends for future legislation. But we also can include suggestions for that future legislation.
which is our definitions and exceptions.
And somewhere, we've got to have a conversation or have how do we resolve the issue that Rich just brought up? Where is that balancing point when you've got people, we need people to vote on the budget.
Yep.
But we believe
Yeah, ethics
that
versus quorum.
that it's not right for someone to vote on a cost of living increase on the pension. So how do you do one and not affect the other? I'd be happy to entertain thoughts on. how
I
to do
think,
that.
like I said, I don't think these 4 people sitting here at this table,
Well,
it should be, actually, I get it, we've got legislation, but I think that the committee, the commission, whatever it is that we have that's written the ethics, that Mr. Lambert is here, right? I think they need to be looking at what we recommend coming out of this.
well, but they could
Group.
turn around. There's no reason why Ned's bill couldn't just be resubmitted the way it is. He could do that.
He could do that.
Our report for November will say generally that it shouldn't go as it's written, right? Just whether between the lines or in actual fact, it should be changed in some
Yes,
way.
yes, yes, it needs to be changed, yes.
So then the question is, rather than wait for another year, how do we want to, as a committee or on an ad hoc basis, create our version of what it should say?
I don't feel comfortable, quite frankly, creating our version of what it should happen, because I'm telling you right
Well, we
now.
basically are.
Well, but no, I mean,
If
I
we're
could go
saying
through
what
this
things-
ethics book and make changes on probably every page. That's not a good thing.
I have no doubt that could.
That's not a
take-
good thing.
Yeah,
But I think that we can make suggestions of what needs to happen to any future legislation, such as honing in on the definitions, put in exceptions for legislators in future legislation. But I think recusal is an important part of this legislation that needs to be there. Somehow, if we can say that, then that gives direction to whoever it is that's doing it, because I don't feel competent not knowing the background and the history and attended these meetings. I just don't.
And any changes that we may suggest, from what I gather, will trigger a rewrite and republication of these rules, and I think
no,
of the booklet.
if whatever we pass.
Correct.
Will change, make.
That's what I meant to say.
Okay,
yes.
I didn't
The
know if you were
legislation-
just
yes.
talking about the
The-
changes we make to the.
But if we recommend this move forward with the particular augmentations that we've described,
Right.
clarification of definitions, that the exceptions for taxation and similar BEP, real estate
Right.
property taxes, et cetera,
And
your
recusal.
domicile issue,
Right.
and balancing the ethics and the quorum with recusal, and making sure we end up with a small card or an app that we can give to these legislators to make things a little bit easier.
It's easier said than done, though.
Yeah,
Yes.
it's
And
much
truly,
easier said than done. I
because
wouldn't end up with a small.
Just the simple thing of saying a recusal on the budget or an omnibus bill. How do you, is it one item in there that's a problem you can just disclose
Well,
it?
we'd have to
or,
address that
you
with,
know, how
it'd
do
have to
you,
be, maybe, you know,
it's a mayor's,
a simple majority. You get 17 issues in there. If you get conflicts with 3, you're good to vote.
is that
If it's
how?
9, well, you can't vote.
Yeah.
Yeah, but that's never gonna happen.
We shouldn't have omnibus bills anyway. That's my thing.
That's-
Hello.
Well,
Yeah.
but the budget is an omnibus bill.
Well,
It's turned into
hello.
one.
It has turned into one.
I understand. And this ethics bill has to deal with the budget
We have,
itself.
we
I
have,
suspect it won't be as omnibus-like going forward.
I
It
have
doesn't
no
matter, 'cause
Because I
idea.
don't think any of us are gonna believe it for a second. and
It
go
doesn't
on.
matter. The ethics rules have to deal with an omnibus or a budget type bill, and and somewhere these guys or us have to say what does the legislator do when he's faced with that situation.
And maybe if we put in there that the legislator can in fact recuse and not vote on it, then perhaps the folks putting together the budget will be more careful of what goes in it.
I like dreaming.
That's okay, I like to dream.
Yeah.
And you know,
Just saying.
So I kind of wish, notwithstanding, and I appreciate you being here greatly, but because we would have been just sitting talking to ourselves, and poor Jen would be dragged into
but
it.
all, you know.
But Ned Gordon is a key player
Yes, he is.
in this, and I think maybe
we
we
all
ought to
understand that. And we know this is the
schedule him
beginning.
for September and say when we wrap this up. Does that sound right?
Yeah, that sounds like,
Again,
perfect.
We
But,
understand.
wait
but
a
over
minute.
the summer, maybe we could, if we could take the notes that were drafted by the clerk and make sure that the rest of the committee has those notes, and that Ned has those notes, so that he could be prepared for those kind of,
And a link to
questions?
the video.
and a link to the video. Why are you,
because I will have to be careful with dates. I've got some major trips going here. September is a period.
I said September, it
Okay.
can be
just like it.
October.
Yeah, okay.
We only need it by November 1st.
Okay.
And
Good.
it's in my lap.
Okay,
Great, I appreciate it again. Thank you very much for all of your assistance. Any comments, questions, or thoughts that you have that would help us?
I hope I didn't make it more confusing, but I mean, it sort of is that way inherently, so.
Yes,
There were some other issues. Do you want to just keep the bill limited to, I shouldn't say limited to, but only about recusal? Because there were a couple of other issues that the committee has, and which may have been something they would have addressed in the Senate.
from that legislation?
No. The committee would like the ability to admonish respondents following an initial review. So I'm just throwing that out there. I know
Yeah,
it's totally
no.
different than recusal. And I could
Is
explain.
any of this in anything other than committee minutes? Or
No,
can we get a copy of those committee minutes?
sure.
And did you define admonish?
Not, we didn't get to that point, no, but following next step in a complaint, which is preliminary investigation, the committee can have an informal resolution with the agreement of the respondent, and then they can admonish. There's been a whole lot of complaints this past year and a half, which are relating to legislator misconduct, particularly on social media sites. And there's the speaker's special committee, which handles some misbehavior issues. And on that, the speaker can write a letter of caution, which he's done. But the committee can't do that currently under its provisions for complaints at the initial level of initial review. And so the committee felt, and they all agreed, that it would be helpful to have that tool where they could admonish at the first level, even without the respondent's agreement, if they've done something that doesn't rise to the level of going forward to a, reprimand, expulsion, or censure, but at a lower level. I'm just saying that's something that,
Is it something less than censure?
yes, it wouldn't be voted on by the body. It would just be from the committee.
And so this presumably would come through the special committee, if the special committee exists in perpetuity here. It would come through that special committee and be referred to
No,
the
well, it
ethics
could.
committee,
No,
or-
this would be a separate, the special committee
you
can do their
envision
own
it?
thing. But this would be for complaints to the ethics committee, which are in their jurisdiction.
Yeah.
They could have the ability to admonish a member and then close out the complaint.
I guess what I'm trying to find out is, could this complaint to the ethics committee be running concurrently with the special committee, or is this a continuation of that process through the special committee to the ethics committee.
This would be separate for the ethics committee.
Okay. Yep.
Just a quick thought. Rather than putting in admonish, would it be in our interest to say something about review remedies available to the ethics committee? Rather than us saying it in,
So they would.
so then
the
they would
ethics
handle
committee-
that under that caption, review remedies available?
Yes,
Is that okay? Okay.
that's.
Because you know,
Are
That's
the
what they were
remedy-
talking
are the
about.
remedies already in this that you have available already in here?
Yes.
Okay.
Under both the procedural rules and also the statute. If you go to page 28, complaint procedures, and 29. Actually, at the top of 29, it talks about upon the completion of the preliminary investigation, which is the second stage of a complaint. The first is the initial review. And to get to the preliminary investigation, the committee needs to vote by majority vote to take it to that level. There, you can have an informal resolution, and it can include, actually, it's not the first paragraph, sorry. It can include,
No
it's B, it's 7B, written advice or admonishment, remedial action, so forth.
so we could put in that, in our little thing to review the remedies available and make recommendations. Okay, and then you could take care of that in whoever it is in future legislation coming forward. Would that be, is that right? If we put something in our,
I don't know. I phased out on that. Say that again, please. I'm sorry.
because when
You
we're talking
wanted-
about admonishment and we're looking at, page 29 of the ethics rules.
Yeah,
Roman
under
numeral
7B.
7, under 7B, for us to word it, put something in there is thing, I think if we are making recommendations.
Well, it does say admonishment in here. Such informal resolution may take the form of written advice or admonishment.
Yeah, but if the committee can't do it, it can only be done by the speaker, right?
No, the committee can
No.
do this.
Oh, the
This is
committee
But
can
my,
do it.
what I'm
committee.
trying to say is it can only do it at a different stage of a complaint and
Oh.
with the approval, the consent of the respondent.
You want to be
You
able
wanna
to do
fix
it
that.
upon initial investigation or something like that,
Initial review.
and
then-
circumvent the
Yep.
the approval of the complaint
Yes,
or the subject of the complaint.
because the committee the thought is this, whatever they did doesn't rise to the level of going any further.
Why would we ever why would we ever have the consent of the respondent to receive?
Because if they say no, it's a formal hearing, which is like a trial. And then at the end of that point, the committee recommends to the House or the Senate reprimand, censure, or expulsion.
Got it?
Would I ask you about two more things too?
Yep.
In the booklet here, there's the harassment policy of the general court toward the end, beginning on page 51. And it's not totally clear that the committee has the jurisdiction to enforce this.
What page?
51.
51.
Why did Ned not include things like this in here? Or is it just
He
too,
was keeping it limited to the recusal.
okay, an issue or two?
This was passed by the Facilities Committee. It was never voted on by the House or the Senate. It's not a law. And there is a piece of legislation which requires that this be in the ethics booklet,
Yep,
but there's nothing that states this is the committee's jurisdiction to enforce this.
okay.
In fact, I'm sorry to have to refer you back again, but in the definitions of jurisdiction of the committee on page 25, there was a specific amendment to jurisdiction of the committee a few years ago which limited the committee's jurisdiction to not include rules.
You know, I think, I think we can go crazy with this right now. I think what
Sorry.
you're gonna have to do, I don't wanna speak for the whole, but my
I think you can.
opinion is, when we're doing this and having our next meeting in September, whatever, October, whatever it is, we need to have this kind of laid out by folks that come
Okay.
in with things that may help us to make our decision in that other session that we have. Because for me to sit here and write everything down like this in September, I'm gonna say, you know. what we got
Have a
right
short
now.
timer, Joe.
Yeah.
Well, I almost think that one of the recommendations might be future legislation dealing with A, B, C, D, so that,
Correct.
so that it is, I don't think we need, there's no advantage to having it added to the existing
Right.
legislation that we're dealing with. I think it would, certainly work in
In a fresh bill.
well, all of this has to be a fresh bill, but in a separate bill. Because you're right, I mean, I can see, well, there's issues with all of those. It's not entirely, I'd like to investigate why, rules wasn't added to your authority. I'd like to
It
know.
was removed.
You know, all of that kind of stuff. I'd like to know whether the special committee that was set up by the speaker will be something that will handle the sexual discrimination. You know, I don't want to confuse what I think is a good start here by adding,
I just wanted you to be aware of them at
Right.
this issue.
and then have a bunch of people recuse themselves from voting on it because they're the whole nother story. Are we good? Are there others on there? But if you
All right,
want
there
to
is
get
one
me a
more-
list
There is
of
one more issue
Yep.
that's bothered the committee, which is the beginning of the guidelines, principles of public service,
What page?
page 1.
one.
I know I'm giving you a laundry list of problems now. But the question is, are those too vague to be enforced? And one member of the committee in particular, David Hess,
Yep.
has really
He-
articulated this very clearly, better than I can do. But we have gotten all of these complaints basically founded on principle 4.
Uh-huh.
And it's, the ethics committee invited the speaker and Representative Wallner to come and talk and have a discussion about the fact that we've got 11 complaints last year and about half a dozen this year based on this. And it's the committee's thought that really, because a member of the public is saying, the legislator was rude to me. He violated principle 4, I'm filing a complaint. And the committee says, well, we're not sure this is really something that we can enforce in terms of a complaint because these are more general and aspirational in nature, even though the word shall is there. And so it's created some bad, as you were speaking, Representative, about the public image. This is really, I think, hurting the committee with the public to the extent that this was known, at least from those who filed the complaints, which are confidential. That they file a complaint under this and the committee says, I'm sorry, we don't really have jurisdiction to help you with that. Yes, the legislator was rude. They did something on social media. They posted this, that, or the other thing on social media, or they yelled at you on the phone or used curse words or whatever. All these things happen. And we'll say, well, I'm sorry. So I guess the question is, what do policymakers want to do with these 4 principles of public service?
Tell them they should adhere to that. It is, did David have a thought on 4 of
On all of them. He said they're moot,
all of them, not just 4?
moot for vagueness, I think is the legal term he used.
Just take it out of the book.
Take all four out?
Well, he didn't suggest that, but I guess making clear they're just general,
It's a wish list. It's nothing that can be enforced, I guess is what I'm hearing. Go.
that's my last laundry list item.
Mm-hmm.
Well, you know, I think that this principle of public service is wonderful. But really, what do you do?
Yeah,
I mean, we take an oath to the Constitution. I mean, that's our oath. We're not.
right. We're not taking an oath to the principles
So-
of public service.
Yeah, remove 1 through 4, I got it. Maybe not that, talk about that a little tonight.
That's interesting.
Sounds like
I'm-
we need some
That's
culture
a,
warriors.
that's a, I'm glad you brought that up.
It's like
Thank you.
It's wishy-washy.
We need some culture warriors.
But if I understand correctly, the ethics committee can remove this all on their own.
The guidelines can be amended by the committee, but it has to be approved by the House and Senate.
It does.
Ah,
By statute?
No, it's a unique process. Where- Like so many.
Page is that a unique process?
How is that?
On,
I mean, this book is in your jurisdiction.
Unique process.
well, yes, guidelines are 27.
Page 27?
Page 27.
On the bottom,
I need a course on this book.
Roman numeral 2.
27.
Two.
Before
And
guidelines
B3.
amendments.
Yeah, and yes.
Before guidelines or amendments become effective, the committee shall distribute guidelines to the members of the, I read this before. Specific guidelines or amendments shall be brought to a vote and approved by a majority vote of both houses within a period of 3 legislative days after distribution before they shall become effective. I would make this almost, I would make this a separate bill, and I would make this almost like we do a CACR, but, you know, it's a very odd little sweet spot of how to. This is a guideline, huh? Yeah, ethics guidelines. It doesn't belong in guidelines, though.
The principles
Yeah.
and complaints have been founded on those too over the years. The Ethics Study Commission looked at this, and previously 4 didn't exist, and the other 3 used the word should instead of shall. And so the commission thought that by changing that word, they were making these mandatory and something the committee could enforce. But the current ethics committee and others who have presented arguments to the committee on behalf of respondents have stated that they thought this was too vague to be enforced because it's not giving the legislator any goalposts as to what is acceptable and what is not.
What would happen if you just simply changed them back to should
That could be,
as a goal?
should aspire to.
Yeah, right. Go forth and sin no more.
And they wouldn't have to bring that before the House? and Senate?
No, that
They
would.
could
If you
just
change
go
that to
forward?
should, that would still have to come before the House.
House and Senate.
Because you're changing the guidelines, and the guidelines according here, before guidelines or amendments are to become effective, they have to be voted on by a majority. But it should be a fairly, I would think it would be a voice vote, but
It's a statutory change. I mean, it's changing the statute, 14B3.
The principles are part of the guidelines.
Well, I'm talking about page 27.
Oh, that
yeah,
process.
27 is 14B3 statute.
That's part of the statute.
Right.
No, we're not changing how the rule is, how the guideline is done. We're changing the guideline.
So you're gonna change this.
No,
No, you're gonna leave this special vote
yes,
the way it is.
yes, you're
So
just
why are we
changing the
talking
guide,
about it?
because you're changing the guideline that
Take
that
that
speaks to, which is this on page 1. You're not changing how the guidelines are done, you're changing just the guideline. It's not a statutory change.
Shouldn't it be statutory change?
No. According to this, it shouldn't.
I didn't know if any future entity would want to recommend that something be done there, that's all.
With this,
To get rid of that,
Or alter it.
all of it.
all of the principles or all of the
Principles.
the rule.
The principles.
Oh, yeah, well, that's, yeah.
In, instead of just changing it from shall to should,
Or
or get
some
rid
other
of it.
language.
Okay. All right, I understand. You're
I'm glad you have it.
all right. I got it. You got it.
I'm feeling very.
You're going to be the one that has to deal with it anyways. All right. We good? Thank you. Yeah, appreciate it. I will entertain a motion for the work session to end,
So moved.
unless I just am getting word from somewhere. Oh, all signature. Thank you very much, everyone. Appreciate it. Closing the work session on 1368.